Hello IP friends, welcome to another episode of IP series with your favorite podcast host Rita and we're Chinda. Now, if you're not following me on Instagram, please do. It's at IP series with _Rita. Rita is spelled REEDAH. I'm also on Twitter. You can find me at IP series 1. We're also on Facebook as well, IP series, podcast, and blog. So today's episode will be featuring a throwback, one of the cases I did prior to starting my podcast, and it's about trademark. It's about confidential information, unfair competition, and how brand owners can actually commercialize their intellectual property. And this, I'm sure when I mention the case, you guys are going to be like, oh, right. Yeah, so it's about DUDU OSUN. If you're based in Nigeria, I'm sure you know the famous black soap called DUDU OSUN. I know some people use it for natural hair, to wash their natural. I have natural hair, and I've been natural since 2014. I love my curls. My curls are always popping. My goal is to get to my waist length, but I think now I'm actually digressing. So yeah, the case is called Mr Chinjindu Chris Maduka against Tropical Natural Ltd. So let's just get right into the conversation for today. So, like I mentioned, the case is between Mr. Chinjindu and Tropical Natural. Now, Tropical Natural Limited is the producer of the famous DUDU OSUN black soap. Now, in this case, Mr. Chinjindu had claimed that he developed the brand of the African black soap and used it for body care products, and started using the mark DUDU OSUN and DUDU OSUM. So OSUN is spelled OSUN, while OSUM is spelled OSUM. And he was suing the Nigerian entity called Tropical Natural Ltd for trademark infringement of the mark DUDU OSUN. He also sought unfair competition and wanted to claim $1,020,665 million rather. So he's claiming that as his profit for the last 6 years. So this case, I reported it in 2019. So 6 years prior to that would be 2013. At least I know my math, which is good. Now, Tropical Natural, as usual, when you go to court and the claimant has made these allegations or filed these processes, you have to respond. So the Tropical Natural responded saying that they were the rightful owners of DUDU OSUN mark, and they also sought to recover $29,000 as profit from the use of DUDU OSUN and DUDU OSUM, which Mr. Chinjindu had been doing for the last 6 years, plus attorney's fee. They were also seeking permanent injunction barring Mr. Chinjindu Maduka from using the mark in question. Now, this case wasn't held in Nigeria. It was held in the United States, which is why you keep hearing dollars. But that doesn't mean you can't claim dollars in Nigeria. Don't quote me wrong, guys. They were also saying that they have to cancel Mr. Maduka's registration because, trademark is territorial. So if you register in America, you get to enjoy protection just in America. If you register in Nigeria, the same thing. So they're saying Maduka's registration for the application for the DUDU OSUN mark, as well as his pending application for DUDU OSUN, should be cancelled. And I know, so I'm going to also do a recording about process to cancel a trademark when a person registered it to deceive the public or has not been using it. So there are grounds to all of that. So non-use is one of them. I know I posted that a few days ago. So you can also check that out. Now you may be wondering what's in a name, especially when it comes to brands and businesses. So if you want to start a business in Nigeria, you are required to register with the Corporate Affairs Commission. That's like a first step. However, when dealing with intellectual property, that may not really save you. So trademark as an intellectual property mechanism is it's one of the ways you can distinguish yourself in your industry amongst your competitors and the rest of them. And it's very important that you choose names that are unique, fanciful, distinctive. They must meet that distinctiveness test. As every entrepreneur who has intention or is in a business venture would require a name as a badge, as a source of origin, as a means of identification, which will consist of personal name. So can I use Rita Enriching that for my business name? Yes, but then when it comes to the trademark element, is Rita Enriching that a unique name? Is it distinctive? Was it coined? All those things. The registry will carry out their tests to determine whether or not your mark meets the requirement. Is it too descriptive? So I'm starting a food business. If I say Rita Foods, that's too descriptive. Everyone knows it's related to food. Same way you have Apple Inc. Apple is a food. It's a fruit, but Apple Inc. is a tech company. Which other name will I use now? I beg Patricia. Patricia is the name of a person, but is the name of a crypto company or a blockchain trading platform in Nigeria. And you do all of this to ensure that your mark is registered and you're protecting yourself from anyone trying to take undue advantage of your brand's reputation and goodwill, and that is called passing off. Now, it does not matter that the kind of business that you want to do is private or public. Trademark helps you differentiate a product or service from one another in order to avoid confusion. So it could be smell. The smells are like non-traditional trademark, but they are also considered to be very difficult to prove the uniqueness and distinctiveness of the smell. Logos, combination of colors, symbols, whatever, names, colors, numbers, like 3-dimensional features such as the shape and packaging of your goods, non-visible signs such as the sounds or fragrances. Basically, a trademark helps you differentiate your brand from another. And once it's protected and registered and you have goodwill, you can sue third parties for infringement. You can sue third parties for infringement. Next up, we're going to be talking about functions of a trademark. Now, what is the function of a trademark? Trademark identifies the commercial and trade origin of your goods that is applied to. In other words, it is seen as a badge of origin, as in the case of Arsenal Football Club PLC against Reed. So if you're an Arsenal fan, please check that case out. If you're also a lover of trademark, check that case out as well. It also helps you advertise the goods and services sold by the traders in connection with the mark, which is known as the investment vehicle. Okay, moving on. It can be an indication of quality. So once someone hears your brand, you're like, oh, that brand is, you can vouch for its quality services or quality brand, as the case might be. Then, for instance, the Christian Louboutin shoes is known for its red sole, which is like the signature mark that can be identified anywhere. And I don't know, within the last 6 years, CL has had a lot of disputes as it relates to his famous red color mark. He recently lost a trademark appeal in Japan for that same red sole color. So, an IP attorney who specializes in trademark would help you come up with strategies that even if you go to territories that have strict intellectual property laws, you can find a way around it that tailors your mark to the requirements in that particular jurisdiction. Scope of protection, it helps protect the work to distinguish it from other goods and services. It gives you monopoly to use the mark in respect of the goods and services which have been registered. So I'm going to throw a little light on that. So we recently had this Augusta Benin's case where it was said his trademark application was in class 36. Now this explanation now focuses on the way it says it gives you monopoly. So this is when people kept saying if he registers something huge in class 36, that means he's the only person authorized to use something used in that particular class. So you have monopoly over class 36 to use the phrase something huge. But moving forward, like I stated in one of my posts, he registering in 36 was a defensive act, protecting himself from potential infringers who want to take advantage of his phrase, which has become popular thanks to this case. But next up is the name, words, and phrases can be protected as trademark as it represents and defines the brand, sends out information, and distinguishes the products and services. And then once you register your trademark, it's protected for an initial period of 7 years. So for the first 7 years, you're protected, but then you have to renew it. So if you've registered your trademark within the last 7 years and you've not paid your renewal fee, please do so. I know the registry is supposed to send you a letter reminding you that you're supposed to renew your mark. But if you've not gotten that letter, yes, reach out to your trademark agent, asking, guy, what's up? I registered 7 years ago, entry due for renewal. So once you renew, you're protected for another 7 years and another 7 years again. So you have to renew at each point until you're tired of using it and it goes into public domain. Now, the conclusion that the court held to this case was that it must be used in commerce, and this could be likened to the principle of first. So in America, they apply the first to use principle, which helps a trademark owner establish their right to use a particular mark and therefore prevent another person from using a mark without permission from the owner. So I'm going to read what the court had concluded. So the court said, on the basis of the court's assessment of credibility of the witnesses, the consistency or the lack thereof of the testimonial and documentary evidence and the presidential case law, the court reaches 9 primary determinative conclusion of law. 1. DUDU OSUN and DUDU OSUM are valid and legally protected trademark. Tropical, not Mr. Maduka, is the owner of DUDU OSUN trademark. Tropical ownership of DUDU OSUN trademark predicted any legally cognizable use in commerce by Mr. Maduka of the DUDU OSUN mark. So the confusion here is DUDU OSUN and DUDU OSUM. And Mr. Maduka had tried to register both mark, whether knowingly or unknowingly, but there already existed a DUDU OSUN owned by Tropical Natural Ltd in the US. Then court also said, because as the parties stipulated, the DUDU OSUM mark is confusingly similar to the DUDU OSUN mark, Tropical's prior use of the DUDU OSUN mark prevents Mr. Maduka from acquiring ownership right in the DUDU OSUN mark. 5. There is Tropical is entitled to a permanent and nationwide injunction restraining Mr. Maduka, his agent, and his employees from any use of either the DUDU OSUN or DUDU OSUM mark or any confusingly similar mark in connection with the sale of African black soap or other body care products. Tropical is not entitled to a disgorgement of profit. Tropical is entitled to attorney's fee. This one sweets me die. Because if you are the attorney for Tropical, let's just imagine what the rate is going to be like in dollars, especially now where the exchange rate in Nigeria is not really funny. The court will issue an order for the cancellation of Mr. Maduka DUDU OSUM registration, and the court will not order cancellation of Mr. Maduka's DUDU OSUM application. So let me just go through my post where I had initially talked about what it takes or what are the requirements for cancellation of a trademark. Trademark. I'm looking for it, but I'll read that to you guys before. Okay, so yeah, you can, your trademark can be revoked or cancelled or struck out from the registry for non-use if you stop using it for at least, I think in Nigeria it's 5 years, yes, and the UK is about 3 years. Non-use for 3 years in UK. I don't know how many years in US, so but I guess I have to do research on that. Then non-renewal, when you're not renewing your trademark registration. Remember I talked about initial 7 years protection, and then you're entitled to another 14 years protection if so far as you do you renew the trademark. Then when the mark was obtained through fraud, when it's likely to cause confusion, like in this case of DUDU OSUN and DUDU OSUM, and then when it doesn't meet the distinctiveness test. Distinctiveness basically means is it new, is it novel, is it unique, all those things. Now, Mr. Abiola Oguride, who is the founder and owner of Tropical Natural Ltd, started manufacturing and selling the African black soap in Nigeria using the word mark DUDU OSUN as far back as 1995. He also gave a detailed explanation as how he came up with the name of the mark, which was gotten from one of the popular languages in Nigeria. DUDU in Yoruba means black, OSUN means camwood. So he went further to show continuous use of the mark between 2002 and 2008, that is 6 years, while Mr. Maduka stated that he started using the mark as far back as 1986, which he also called DUDU raw black soap and liquid black soap. But Mr. Maduka and Mr. Abiola sold soap products, including the bar soap known as African black soap in the soap industry, popular in Nigeria. How many of you have seen? Okay, I mean, this case is, so I talked about this case in 2019, so this is like 3 years ago. And it was also popular in the United States, especially amongst immigrants from West African nations. According to Daniel M. McClure, he was of the opinion that the history of trademark law was seen as playing at the tension between protecting entitlements on the one hand and encouraging free market competition with access to other protected marks. I hope that makes sense, but if it doesn't, send me a voice message and I will do my best to respond. Well, in this case now, you can see that the party tension in protecting their entitlements on the one hand and also encouraging free market competition with access to other protected marks. Same is applicable in every other intellectual property. And with invented words and names and phrases, it is easier to protect as it comprises of different combinations to create and represent the brand. And they're also common words, or they're not common words or terms that can be found in English dictionary. For instance, DUDU OSUN, I don't think you can find DUDU OSUN in English dictionary. Brand names can be referred to as trade names, which gives protection under the trademark to control unfair competition and dilution of a trademark. A brand name is its identity to a product, and that's what makes them stand out from other products and services. It has also been said that most brands speaks for itself, hence they make the product quality and price higher than its inferior, which is why you see quality goods are more expensive than sub qualities. And in the US, trademark names are given utmost protection due to the fact that they represent the brand under both the state and federal law. Now, under the Supreme Court in the United States, the federal trademark law has two objectives. One, protection of consumers' ability to identify and distinguish products of various manufacturers. Two, protecting the business goodwill which a mark symbolizes. Now, in Nigeria, the case of Ferrodo case is the foundation, or as we call it, the locus classicus of trademark law in Nigeria. You have the Niger chemist against Nigerian chemists case, and then you have DK Brown on pronunciation, thereby causing confusion. So DUDU OSUN, DUDU OSUM. I also recently saw a post where some an American was opposing the registration of Africana because he registered Americana. So does pronunciation actually cause confusion? Is that a ground for likelihood of confusion? I guess so. Then you have Ike Merchandise against Pfizer Inc. and others, where these two words, combatrin plus and combiterin, were the cause of confusion. The DUDU OSUN, DUDU OSUM. In Omnia Nigeria Limited against Dyke Trade Limited, the issue was on the use of the word or phrases super rocket, and the plaintiff had to obtain an atom pillar order against the defendant in that particular case. Then challenges in trademark. 1, dilution of names. This is said to be reducing a brand's value, thereby making the consumer think it is unique or particular and singular. It is also being made up of 2 particular harms, namely blurring and tarnishment. Now, blurring is by associating another mark to another, while tarnishment is based on the reputation of a famous brand that is now associated with another brand. Now, the United States enacted the Federal Trademark Dilution Act, which was established in 1996 to actually prevent dilution in any form. Then we have issues of counterfeiting and piracy, where people buy counterfeited products and that ends up violating the real author's right to earn, and also causes harm to consumers who are vulnerable to some risk, for instance, poisoning. And then every country is affected by counterfeiting and piracy. Therefore, the law enforcement agency and custom official worldwide should work in tandem, and also trade laws should be created in order to frustrate the efforts of these impersonators in shipping, distributing, and selling of this product. Then another challenge is passing off, which is in relation to not just pronunciation and similarity, but happens when 2 products have the same spelling but different pronunciation, which of the owners should be given the right to own the mark. So in the case of selling, Sal is spelled SARL, against selling SA, it was held that there was no infringement. However, the Nigerian case of Niger Chemists against Nigerian Chemists beg to differ. Things are always different in Nigeria. So yeah, when people say we don't have laws or we don't have cases or precedent, please, we do. Just, it doesn't take you a while, but trust me, we do have cases. Now, we'll look at the claims of the parties as they are seeking to recover a certain amount of profit made in the last 6 years, as between 2013 and 2019. Yeah. Tropical Natural is asking for $1 million plus, while Mr. Maduka is asking for just $29,000. Now, proof of ownership under the Lanham Act in the United States for trademark is based on the first continuous use of the mark, which Tropical Natural did between 2002 and 2006. And ownership is not acquired by the federal or state registration, but from prior appropriation and actual use in the market through the sale of goods and services, while using it for commercial purpose. And then use in commerce is defined under the Lanham Act as the bona fide use of a mark in the ordinary course of trade and not made merely to reserve a right in a mark. Now, in Nigeria, we apply the first to register. So it's the person that registers the mark first in that class that gets to enjoy the benefit and the monopoly that comes with, owning a trademark. Now, costs in the circuit also consider the following factor. 1, the volume of sales of the trademark product, in this case, that's DUDU OSUN, which Tropical Natural showed to have imported into the United States from 2001 over 150,000 bars of their DUDU OSUN up until 27th of April 2016, and showed a document of another 48,000 bars sold to different distributors in Virginia from May 2002, and they made about $28,000, while Mr. Maduka had less than $3,000 and even sold some of Tropical Natural branded products. Now, could that be considered to be passing off or an infringement? You guys tell me in the comment section. Then the growth trends are both positive and negative in that area. Number of persons actually purchasing the products in relation to the potential number of customers, and Tropical Natural had the numbers. And finally, the amount of product advertised in that area. Tropical Natural advertised their own brand in the African imports catalog in the fall/winter 2002, and also the summer 2004 edition, the spring 2009 and spring 2011 edition. Mr. Maduka did not even do any of that. He did not even meet market penetration. He didn't do anything. Ownership in Nigeria under Section 18, Sub 1 of the Trademark Act is any person claiming to be the proprietor of a trademark used or proposed to be used by him, who is desirous of registering it but must apply in writing to the registrar in the prescribed manner for registration, either in Part A or Part B of the register. Now, what is deemed registrable under Part A and Part B is the difference. What is the difference? The mark registered in Part A must be distinctive, which is defined by Section 9 of the Trademark Act to be that the work is adapted in relation to the goods in which it is registered to distinguish the goods which the proprietor of the trademark or may be connected in the course of the trademark. While registration in Part B of the mark must be capable in relation to the goods in respect of which it is registered or proposed to be registered, and doesn't have to be distinctive, but they must be capable of being distinctive. Now, what are the defenses or remedies for a trademark? Remedies include one, an injunction. You can ask the court for an injunction preventing the person from further distributing or producing. You can also ask for damages, restitution of unjust enrichment and recovery of reputation, as if your goodwill or reputation was harmed. Then your defenses or exception includes extopel, doctrine of laches, fair/collateral use, and unclean hands. And one of the claims that was made by Tropical Natural Ltd was that they requested Mr. Maduka's application and registration of the DUDU OSUN mark to be cancelled, and the court on the issue of cancellation ordered the United States Patent and Trademark Office to cancel Mr. Maduka's DUDU OSUN registration. Now, I'm going to read, as of 2019, trademark registration ID was 3,111,704. Now, look at that number again, though. Now, I'm not sure we keep records here in Nigeria where, because I follow a lot of intellectual property offices, both on Twitter and on LinkedIn, and they always post highlights and celebrate landmarks and the rest of them. I'm not sure the registry in Nigeria is even up to 3 million. So that means we have a lot of work to do. And the reason for that was that they said the mark was invalid because Tropical Natural Ltd had wide priority to the DUDU OSUN mark before Mr. Maduka. Now, on the other issue of cancellation of the pending application, so because you started an application at the registry doesn't mean you own the mark. Your application is still pending, so we need to get that straight. So the fact that you have gotten your acknowledgement or acceptance letter, it doesn't mean you've gotten the mark. It is still a pending application. Anything can happen, especially at the opposition stage. So we got to be careful. So now, on the issue of cancellation of the pending application, the court held that it had no jurisdiction to cancel a pending application which had not matured into a registration. So what is the difference between an application to register a mark and an actual registration? Now, application to register a mark can be likened to the search stage, while the actual registration is the step taken by the applicant to get extra protection under the law in order to have exclusive rights to the mark. So I'm going to read out. I know I did this during the August Avenues case. So when you read out the steps to register your trademark in Nigeria, first you do a search by carrying out a search at the registry to confirm the availability of the mark that you wish to use in question. Then you comment with your filing when you get your search report. Once that is filed, the details are filled online. You get an acknowledgement copy after filing. Then you could either get an acceptance letter saying, okay, we've accepted your application, or we are rejecting it, and giving you information that, okay, this won't fly because it doesn't meet the basic requirements, etc., etc. Then you now move to the publication in the journal. This is a very compulsory stage. So life case, I had an instance where someone referred someone to me for a trademark registration, and after I pay for consultation. So I'll basically be sure that his mark in question was distinctive. Let's just have that pre-registration conversation, because sometimes you're advising clients that, I don't think this mark will fly to you, like, oh, just fill in the application. You're telling them, if you fill it in and it's dismissed or it's rejected, you have to start all over again and pay new fee. And you're like, oh, and he goes, oh, someone already, I got someone cheaper and I'll get it in 2 weeks. And I was like, oh, really? 2 weeks? Where the law prescribes 2 months from the date of publication for opposition, giving third parties the opportunities to come and oppose your trademark application, and someone is saying he will get you everything, including certificate, in 2 weeks. Good luck, fam. Not going to stress. But yeah, then the final stage is issuance of certificates after publication has been confirmed. That's another, legwork, but let's move on. Right. In Nigeria, any person may, within 2 months, I already said that, from the date of advertisement in the journal of an application to register a trademark, give notice to the registrar of their intention to oppose registration. Now, Section 20 of the Trademark Act, Sub 2, provides that it must be in writing and shall include the statement of the grounds of opposition. Sub 3 says the registrar will send a copy of every notice to the applicant of the mark, and within 1 month send a counter statement of the ground which he relies for his application. And if he doesn't do so, it will be considered to have been abandoned. So make sure you get things right, so you don't have issues with people and arguing back and forth. You get. Then another interesting thing is that sometime in August 2014, Mr. Maduka, owner of DUDU OSUM, that's the one with the M, claimed that he sent a cease and desist letter to Tropical Natural, but he never got a response. However, in August of 2015, Mr. Ignatius Chibututu, Tropical Natural's lawyer at that time, sent him an email asking if he'll be willing to sell or assign the DUDU OSUM mark to Tropical Natural. This kind of reminds me of the Facebook Meta trademark case, where it was said that trademark Meta now had reached out to someone using that name, a small company, saying they wanted to buy them off, and they did not want to. Now Maduka refused, but offered to license DUDU OSUM, that's OSUM, to Tropical Natural. So before I even go any further, I'd like to state that there's a difference between licensing and an assignment. Now, in a licensing situation, the licensor now, who's the person that owns the mark or the intellectual property, still retains his intellectual property rights, as he only gives permission to the licensee, who in this case will be Tropical Natural, to use one of the rights or more of the intellectual property right for a period of time, while an assignment is actually you're actually transferring all your rights of ownership, and it's a one-time transaction. So in the case of an infringement, an assignee can sue, while for licensing, it is only when it is an exclusive license that the licensee can sue. So if you get a non-exclusive license, you can't go and sue other people. See, come, I have the right to use it, you don't have the right to use it, because one, you're not the licensor and you're in a non-exclusive relationship. An exclusive one gives you authorization within that particular territory. For instance, Nigeria, you see another third party using fluffy pie Limited or Fluffy Trademark or whatever, and you are the only person licensed in Nigeria, you can send a cease and desist letter. Speak to your intellectual property lawyer on your retainer, please. And the decision previously made is that it's important to determine who has a right to sue in the event that there's an infringement. And Mr. Maduka later sent a proposal to Tropical Natural and referred to DUDU OSUN as Tropical's brand. Very interesting. I mean, how you claim that you own a mark, but then you're not calling another person like the rightful owner. So you've already shot yourself in the foot. Anyways, parties couldn't agree on terms, and in April 2017, Mr. Maduka filed the lawsuit against Tropical Natural, asserting, among other claims, trademark infringement and unfair competition. Now, Tropical Natural responded with a counterclaim on the same issue. If you had come across the posts in 2019, I'd shared pictures of what the primary and determinative conclusions were, and the other. I think I've read the first conclusion. The other is, so let me just go through it. And now on this 10th day of September 2019, following a non-jury trial from April 29, 2019 to May 1st, 2019, upon consideration of the parties, proposed finding and facts and conclusion of the law and the parties' statements of damages, and following an oral argument on the proposed finding of facts and conclusion of law on July 12, 2019, it is ordered: 1. Judgment is entered in favor of Tropical Natural Ltd. and against Mr. Maduka or Mr. Maduka's trademark infringement and unfair competition claim. Judgment is also entered in favor of Tropical Natural. They also permanently enjoined Mr. Maduka from using DUDU OSUN mark, DUDU OSUM mark, or any confusingly similar variation thereof in connection with the sale of African black soap and other body care products, including without limitation soaps, shampoos, conditioners, lotions, cream, oils, body balm, facial cleanser, and moisturizers anywhere in the United States. The United States Patent and Trademark Office was directed to cancel the trademark registration of DUDU OSUM. So the registration ID number was 3,111,704. Bust my head though. The clerk of the court shall certify this order to the Commissioner of the Patent and Trademark Office. Tropical Natural shall submit to the court an authenticated accounting of its attorney fees and costs associated. A hearing notice shall be noticed and held concerning the claim of fees. Mr. Maduka may file a response to Mr. Tropical's, as in Tropical Natural Limited, accounting of attorney's fee within 14 days. So now, what's the difference between that's about the conclusion and the order? I read the conclusion earlier on, 9 of them. This one is just the order that was given. And then what's the difference between a trademark infringement and an unfair competition? So the difference is that for a trademark infringement, in order for you to protect an unregistered trademark, 2 points must be proved. 1, ownership of the mark and that it functions as a mark in relation to the goods and services in question, which Mr. Maduka failed to prove that there was an unfair competition. The trademark infringement is the unlawful use of another person's mark with the sole purpose of causing confusion among the consumers. And under the Nigerian Trademark Act, Section 5 sub 2 defines what a trademark infringement is. So I'm trying to see if should I read that out for you guys? I don't think so. Another issue I would like us to consider in relation to this case is intellectual property rights, trade dress, and packaging in Nigeria. But I think I will do that later. And in conclusion, so to wrap up this conversation about this case, as a brand owner or as a trademark owner, please know the value of your brand, have a good marketing strategy, understand the importance of documentation when it comes to intellectual property. Now you can see that Tropical Natural had shown documentary evidence from publications in the catalog to stating how long they've consistently used the mark for comments between 2002 and 2008. Mr. Maduka basically didn't really do much to show and prove that he was the real owner. And also in a territory that applies the first to use system, he should have done a lot more. I mean, saying you started using the mark in 1985, were you consistent? I don't think so. But Tropical Natural had gone to show that they were consistent for at least 6 years prior to the suit. And even, I don't know about now, but yeah. Your right to use the right exclusively while preventing another person from attempting to copy your mark. Appearance matters a lot. Always go for a multi-tiered protection when it comes to intellectual property. I always say this a lot when I have conversation with my clients. So you're just thinking about trademark. Well, I want to register my name. What does your business do? I like to have, that's why consultation is very important, because we'll talk about all the available multi-tiered protection that your brand needs. Finally, build and have a positive image, reputation, and goodwill for your brand, so that in the event of a dispute, your goodwill and reputation will really come true for you to save you, like when you need evidence of ownership, it's right there looking at you, staring at you. So yeah, I hope you guys found this throwback series very, very interesting. I mean, it was very insightful for me. I hope it was as well. And so we have come to the end of this episode. Thank you guys for listening. As usual, if you want more throwback series in the podcast version, just send me a link of any of your favorite past IP series stories. We are in the season of election. Please guys, get your PVC. 2023 must be lit. We must get it right this time around. I mean, most of us who were claiming not to be eligible to vote, we are not eligible to vote. If you want to do a transfer from your local government or wherever you were, do that. If it's not possible, get a new one, but make sure that you go out in masses to get your PVC. Get your PVC, guys. Okay, I think I'm done. Yeah, thank you again. Don't forget to subscribe, follow, so you don't miss out on any episode. Cheers guys. Mwah. Lots of love.